Sabine versus State of New York.
Good afternoon. Michael Kenny on behalf of the appellant, Michael Sabine. And if I may, Your Honor, I'd ask for 2 minutes in rebuttal.
Yes.
Thank you. At the outset, I'd like to thank this distinguished court for its time in addressing this issue as to when a claimant or plaintiff is entitled to prejudgment interest under CPLR 5002 in a bifurcated trial. The issues we're going to talk about today center around three basic things. Section 5002 of the CPLR, Section 5102D of the New York State Insurance Law, and Section 5104 of the Insurance Law.
Counsel, I think it's four things. The first one is preservation. How is this issue before the court?
Let me address that. As the record reflects, at the end of the trial, when we got the decision from Judge Fitzpatrick.
What decision are you talking about?
The damages decision, okay?
Okay.
We reached out to the court, as is our process and practice, and we presented at a proposed judgment. The clerk of the court said no. We reached out to Judge Fitzpatrick's court again, and they said to us.
They said who actually said to you?
Sean Gleason, which was Judge Fitzpatrick's law clerk, reached back out to us, and it's, I think, on page 466 of the record.
This is the email you're referring to?
Yes.
And has this court ever considered preserved an issue between an email between a party and a law clerk?
Well, I can take that a different way, too, Your Honor.
Well, take it the way I'm asking first. Have we ever done that?
I don't know that you have done that. As a practical matter, Judge, we did present this to the Court of Claims, maybe not in the form of a motion, but we were given the option.
Well, was the
The
judge
option
CC'd
of-
on that?
Excuse me?
Was the judge CC'd?
Oh, it came from the judge's chambers.
But was the judge CC'd?
Judge CC'd as
Judge
a...
Fitzpatrick? How do we know that Judge Fitzpatrick actually weighed in on this?
Well, Sean Gleason was Judge Fitzpatrick's law clerk, and he was part of her staff.
I believe he said in the end of that email, you may make a formal motion on this, correct?
That's
Yeah,
correct.
so doesn't that indicate that this discussion that you were having over email was not a formal motion and was just an informal discussion that the law secretary was basically saying to you, if you want to take this up, take it up in a formal motion like we normally do?
I believe that was qualified if you have additional cases outside of Rizicki. And in that sense, right, so the issue was brought up, but to move it beyond...
But is that a determination for a law clerk to make? I mean, the invitation to make a motion seems to be to raise these seemingly valid legal arguments regarding the applicability of Rizicki.
Right. Well, is that reasonable? It is reasonable in practice, right? On the flip side of that, given that Judge Fitzpatrick was bound by Rizicki, clearly in the Fourth Department, what we would have done is we would have...
Well, but counsel, you're making arguments here today that Rizicki, are you just asking the court to overrule Rizicki? Because I saw you cite to the law in other departments, changes to the law post-Rizicki, and I think in this case you even have an argument that you have a liability judgment, not a negligence judgment. These are all issues that could have been raised directly to the court in the context of a motion, and then they would have been, for lack of a better expression, you would have put the court's feet to the fire to address all of those issues, but none of that happened here.
Right, you're absolutely right. So what we did is we brought it up to the Fourth Department.
But they have authority to consider issues that aren't preserved. So when you got that email, it lays out two choices. You could go preserve this issue and make a motion in front of the trial court, which you chose not to do, or you could raise it in the Fourth Department, where they can consider anything they want. We can't. So when you didn't make a motion, it's unpreserved for us.
Well, I believe that under Tellaro, that since it was a pure question of law, that we have the ability.
But even assuming Talaro, which we've applied 4 times in 55 years, would apply here, what about Judge Canataro's point that
You had legal arguments to make.
legal argument?
Yeah, and as a practical matter, and in reality, what the situation was is that it, number one, adds additional burden on the court. It adds an additional burden on the state because she was bound by the ruling in Rizicki, right? So we could have made that argument. We absolutely could have in the form of a motion, but we were given that option, as the chambers indicate to us, either make the motion
So are
and
you
show us some
making-
additional law.
Are you making a futility argument because the court, you say, was bound by that precedent?
Well, what I'm saying is that she was bound by that precedent in Rizicki that the Fourth Department came down with.
But
So-
if you made the motion and there's a ruling,
Right.
arguably, there could have been something offered to the court to make a determination as to whether or not it was to be followed, if it was still good law,
Well,
even in the very least.
her chambers indicated it was still good law, and that was their position. And when
I
we
think my colleagues raise a very valid point. You refer to the chambers, to the law clerk,
Yes,
but not the judge.
That's
Not
right.
the judge so holding or anything of the sort. These are inquiries. Inquiries are made to chambers all the time, and you are not suggesting that the clerk said that their opinion was that of the court, or are you?
I'm saying that the law clerk, Mr. Gleason, in this situation, indicated to us that based on Rizicki, the court was not going to change.
So the law clerk and the judge are the same, is that what you're saying?
I'm saying that the law clerk is under the guise of the judge, yes. And this is how this.
What does that mean, the guise of the judge? The law clerk speaks for the judge?
Well-
The law clerk's statement is the law of the judge?
Well, I don't want to be so presumptuous as to say that, Judge, because that wouldn't be fair. But what I am saying is that when Mr. Gleason reached back out to us relative to the fact that that Judge Fitzpatrick was going to apply Rizicki, and hence there wasn't going to be any interest flowing from September of 2018 until the date of the damages decision, that's in essence what they were saying, yes.
Was this typical practice in this litigation, where the clerk would communicate the judge's position
Yeah, I mean, when
outside of the judge's presence?
right, as a matter of course, we would reach out to the clerk for guidance in these matters, and as a result, the clerk would respond with that.
What about a ruling on a question? In other words, guidance might take the form of how many pages for this motion, when should it be filed, all those sorts of procedural issues. But was it practice to ask for a ruling on a contested question from the law clerk via an email and to receive one without any direct engagement from the judge?
So if were you using the example, Your Honor, of the number of pages or something along those lines? If that was the case, absolutely.
Yeah, but something, I'm asking, something that is not procedural,
Oh, I see.
mechanical, something that is a substantive question, was the practice to obtain a ruling from the clerk as opposed to something from the judge directly?
Yes, and this hasn't just happened in this case. It happened in other cases as well, when we would have rulings for depositions, for instance, and there was a question that arose during a deposition. We would reach out to the law clerk, and the law clerk would respond to us. So
And is it your position here that we should encompass that practice within our preservation requirement? In other words, equate a law clerk ruling with a judge's ruling for purposes of preservation?
In terms of preservation, I would say that I would ask this court to rely on Tolero, right? And say that this is a pure question of law, and that at any time, the appellate division could take that issue up, could address that issue, which they did in this
Tolero
case.
requires more, with all, notwithstanding what Judge Garcia said about the paucity of instances where we've applied Tolero, it involves more than just being a question of law. It requires the existence of available legal arguments and countersteps that could have been taken to diminish the other side's position. And you seem to have acknowledged that you had arguments to make. You just chose to accept the invitation to go directly to the appellate division without making a motion first.
As it relates to that, I'd like to bring up to the court that those are not, there were no factual issues as it related.
I'm not talking about factual issues.
Yes.
I'm talking about legal arguments.
Right, I'm talking about legal arguments too. There were no factual issues that the other side had any.
So anytime there's no factual issues, we can just hear new theories here as long as we don't have to find new facts?
Your Honor, I believe that in this situation, we did reach out to the court. We did make an attempt to address this issue. We were given the option of taking it up to the appellate division, where
Where they can hear anything they want. They have that authority that we do not.
Can I ask, what would the argument have been if you had made it in a formal motion? Would it have been that Rizicki was somehow distinguishable, that it was wrongly decided, and you would be making a record for further review? What would you have done if you'd filed a formal motion?
I would have said that Rizicki was wrongly decided.
But not that it was distinguishable.
Right. And I would have said that it was wrongly decided based on Van Nostrand and Justice Dillon's decision therein. And we can talk about the other things, but if you would like, that's up to the court. I'd like to address it. If 5002 of the CPLR and the language therein sets forth that interest shall be recovered upon the total sum awarded, including interest to verdict, report, or decision in any action from the date the verdict was rendered or the report or decision was made to the date of final judgment.
And how is that impacted when you have a bifurcated situation?
Well, this court's already determined that, right? Under Love versus the State of New York. Love versus the State of New York was out of the very same court of claims that this case is, right? And in Love versus the State of New York, there was a bifurcated case. It was an automobile crash case, and there was a determination by Judge Margolis in that situation that liability attached, that the state trooper violated the vehicle and traffic law and injured Mr. Love, okay? And as a result of that, there was a subsequent damage determination, and that damage determination resulted in a certain sum certain. So what this court said is that the interest is to be determined from the date of the liability, that the liability was established. In that case, the liability was when the driver, the state trooper, violated the vehicle and traffic law, and that was determined.
I thought we said there that it starts to run when the defendant's obligation to pay the plaintiff is established. And I don't see how that is established until serious injury is determined.
Serious injury.
Well, is there an obligation to pay unless and until serious injury is established?
Yes, Your Honor, there is. Because serious injury is not an element of liability.
But I take your point, but is there an obligation for a defendant to pay if a plaintiff cannot and does not establish serious injury? I thought under the statutory scheme, the answer is no.
Under 5104, that's clear, right? In order to
Right.
recover.
So how is there an obligation to pay until that is established?
Well,
Seems to me that's why, just to ask you to address one other case quickly, because I see your light is on. In Lakari, I thought that we determined that the case should be dismissed if there wasn't a finding of serious injury. So I struggle to understand how there is some obligation that could attach before the finding.
so if you look at it in the sense of what serious injury is, it's naturally a damage question. It's related to the 9 criteria under 59
Yeah.
or 5102D. And if you were to look at a bifurcated trial, the first part of it, we're going to try duty, right? Lack of duty, right?
Yeah.
Breach of the duty, and then we're going to later on try the damages. And that's part of damages. And what Justice Dillon sets forth in Van Nostrand is that the fault issue, right, the common law liability issue is separate and apart from the damage issue which the serious injury is done, right? When we try a case in real life, in a bifurcated sense, we are trying liability first. We are
Yeah,
trying.
but that, what about the effect of the no-fault law? Doesn't that change that paradigm?
No, it doesn't at all.
Why not, though?
Because, and certainly I'm not going to be able to express it as eloquently as Justice Dillon did, but in that situation, right, all it is an element. It's no different than.
Right, they're saying liability won't attach until serious injury is proven.
No, that's not what I'm saying at all. In fact.
No, I know what you're saying, I'm asking what the law says.
Right, well, the law doesn't say that either, because 5104 doesn't say that. Certainly 5102D doesn't say that. And on top of that, 5002, which was interpreted by this court in Love and later in Denio, right, that doesn't say it either, right? So what the situation is that serious injury and liability are two separate things, right? And serious injury is nothing but another aspect that we have to try when we try a
Well,
lawsuit.
if you don't prove serious injury, could you, what's your damages award?
0.
Okay, so how does that support your position?
Okay, but if I have summary judgment on a slip and fall case, right, to use an analogy, and I go in and I can't prove any damages, what ends up happening?
Yeah, but that's different, that's damages. Here, we're talking about liability.
But you're conflating the two. There's two different aspects.
In the example that you gave of summary judgment where the damages number is 0, I don't think that gets dismissed on appeal if that's the finding. I think that the damages are 0, but it seems to me that what we decided in Lakari is that it should be dismissed. And that's what indicates perhaps that there was no liability that attached absent a finding of serious injury because of the differences in the no-fault scheme.
To use the language in Van Nostrand, it's a distinction without a difference. The situation is if you don't meet that threshold, right, under 5102D, you can't recover non-economic losses, pain and suffering, right? If you had a case of property damage and a question of serious injury at the damage trial, right, and you didn't meet the threshold under 5102D, but
It may not matter as to the plaintiff if the plaintiff is getting $0. I appreciate that, but it does seem to me, and I won't continue, but that there's a procedural distinction between a dismissal and a decision that the damages are 0. In terms of the way we think about the disposition of a case.
I appreciate that. Anything else? Thank you.
Thank you.
What is the effect of a finding of liability in a bifurcated trial?
Thank you, Judge Troutman, and may it please the court, Frederick Brody for the state. Answering your question, the effect of a finding of, quote, liability depends on what's been litigated. If only negligence was litigated, it's not really a finding of liability in a no-fault case, because before you can hold someone liable in a no-fault case, you need serious injury.
So what does that separate determination mean? That in this instance, there was a liability finding, then damages was separated, and you have to establish that there was something recoverable, correct?
Correct.
And in this instance, we're talking about when prejudgment interest attaches.
Right.
So that liability finding means nothing?
No, the liability finding, let's say it's a finding of just negligence. It's like summary judgment on an element of your claim, or a trial, a separate trial under, I think it's CPLR 612 or 512, separate trial on one element of your claim, which can be done. That element's taken care of. It's adjudicated in favor of the plaintiff.
But it's not enough for the clock to begin to run, is what you're saying?
Correct. And here's why. Under insurance law 5104A, unless the claimant proves serious injury, quote, there shall be no right to recovery, close quote, for non-economic loss.
Counsel, I've always understood, I've done my fair share of motor vehicle cases with threshold issues. I've always understood that to be exactly what the statute says, a statutory bar to recovery, a completely legislatively created creature that, in my view, is enacted to effectuate the purposes of the no-fault law. The legislature, in order to have no-fault be meaningful, decided to shunt a whole body of cases into the no-fault system by barring a recovery in court. But to me, it never spoke to a party's fault, and it doesn't even speak to damages, because you could have very significant damages in a case, they just don't happen to meet a very arbitrary list of damages that will qualify you to get over the threshold. So I have a very hard time understanding, let me just say it, I have a hard time understanding how it's a bar or how it affects liability when the legislature itself calls it a bar to recovery.
Well, it doesn't say a, quote, bar to recovery. It says you have no right of recovery, and I
What's
think
the
that,
difference?
yeah, the term right is critical because it goes to the
Can you tell me?
existence.
Yeah, go
It
ahead.
goes to the existence of a cause of action. Rather than limiting damages, it abolishes a claim. And it does that, and this will address.
But I agree with you, but it doesn't abolish the claim because the plaintiff can't prove fault, and it doesn't even abolish the claim because plaintiff can't prove some amount of damages. It just abolishes the claim because it doesn't meet an arbitrary standard for letting the case stay in court. If there were no no-fault law, that case could definitely go forward in court, and plaintiff could recover damages. They might be small, but they could recover damages. You agree with that, don't you?
Yes.
So if there were not a no-fault law, then this would be like any other case in Supreme Court or county court or whatever court you want, and a ruling on summary judgment on liability would entitle you to prejudgment interest, wouldn't it?
Yes, you and I are agreed. Now, what's the effect of the no-fault law? It adds by modifying the common law. And remember, it's a statute modifying the common law to add an element. So it's not enough to prove just negligence. It's not enough to prove just some damage. You have to prove one of these 9 categories, or however many there are, categories of damages, as an element of your case before there can be liability.
So you have a departmental split here, and you have the appellate division here saying this fits in the Tolaro exception. What's your position on whether it fits or doesn't fit?
I think it fits within the Tolaro exception. We
Because-
didn't argue preservation below. I think, Tolaro exception is, one moment, Your Honor.
And I assume you'd like to have the split resolved.
I think that the split's been hanging there since 2007, so
Does it cause you any problems?
does it, well, it's $150,000 at issue in this case.
Well, I didn't mean this case. I mean, you litigate these presumably more, not you personally, but the state does, and probably would like to have a uniform rule on this?
Certainly, a uniform rule would be a good thing, and
Well, there are no shortage of motor vehicle cases with threshold issues out there, right? If this case isn't preserved, the next one will come along in short order, I'm sure.
well, I don't know about short order, because again, the last
winning
one
that
that was up
much.
here was 2007.
Yeah, you're winning that much, it's not going to likely to come along. So do you think as an institutional matter, appellate court should certify a question of law to us that's unpreserved on the issue, on the hope that we're going to apply a Tolaro exception to it?
I suppose that's what happened here. If the court doesn't think the Tolaro exception applies, I'm perfectly happy, we win. Fourth Department gets affirmed. That's why we didn't brief preservation. That's
Well, if
all
he
I
had
can tell you.
filed, if he had filed a formal motion pursuant to the clerk's, I don't know what to call that thing, clerk's statement in the email, what would you have said? Would you have said anything different from what you would have said to the appellate division?
We would have said that Ruzicki is the law of the department.
Well, the clerk wasn't inviting you to make a motion, were they? I thought they were inviting.
No, no,
plaintiff.
but
Right,
that's not the question.
I think-
Yeah, go ahead.
Yeah, I think Judge Rivera was asking me, what would I say in response to
you
the
argue?
motion?
Yeah.
And my response would be that Ruzicki was the law of the department, and it was
Which is
also
the same
correct.
position you take at the appellate division,
The same
right?
position we took in the appellate division.
Same position, there's not
and in
anything
this-
different, and you agree that the trial judge is bound by the Fourth Department?
Yes.
Counsel, I know your office appears in a lot of cases across the state. So is your decision not to press preservation here, picking up on the Chief's question, do you have a broad view across cases that Tolaro is an available exception here? I mean, would we expect to see the same position taken when preservation might benefit you in a different case?
I can't speak to the hypothetical of a different case. 'Cause
Well,
I'm
I
not-
think
I'm
you
not gonna know
understand
the
what I'm
dynamics.
getting at.
But,
Is
you
it
know,
a reading of Tolaro, or is it more specifically the point that because you benefited from the decision, it was not something that you invoked as a way to keep us from the merits?
Often arguments morph at the appellate level.
And is that true about the Tolaro point?
That's the Tolaro point. Tolaro is a useful procedural device to reach arguments that may
Do
not
you know
have
the
been-
last time we applied it that way? Do you know what year it was?
It was a while ago.
1986. And
that
this is
sounds
the
about right.
question that we should apply it to in 35 years or whatever that is. This is the next one.
I mean, again, Your Honor, if the court does not think Tolaro should be applied, and the court certainly has discretion to apply it or not apply it, then we win, and I can sit down. But I do want to say a little more about serious injury before I sit down. And what I want to say is that the court has described serious injury as a threshold question, and it's a threshold, again, this is going to Judge Canataro's inquiry, it's a threshold for the right to recover, and thus for
But
liability.
under your analysis, it means that even those claimants who succeed on liability, on the first part of the bifurcation, and then succeed on the damages and show serious injury, can't get the interest. And that strikes me as wholly unfair. I mean, there's something wrong with that.
Well, I'm not grasping Your Honor's hypothetical. You're saying they succeed on
Right,
negligence.
look, it's dismissed when it's zero. But if they actually establish serious injury, why shouldn't they get the interest? You've been able to profit off the money that would have been theirs otherwise.
Well, they get interest from the point when serious injury is established. Yes, so I agree they get interest. The question is, when does the
I know
interest
that's
start
the
running?
question, but all I'm saying is any other plaintiff would have been able to get that interest.
If there was no no-fault law, this plaintiff would almost positively have been able to recover prejudgment interest from the date of the liability verdict, judgment.
Absolutely, but in the no-fault law, the legislature specifically disfavored automobile accident negligence cases.
But not the ones that fit this particular framework. And then they are being treated less favorably, even though they meet the higher standard that the legislature has set out.
Well, I think there are good policy reasons for the
Well,
structure.
they're good, certainly we understand the policy behind the no-fault law. We've talked about it in the past. This is about prejudgment interest, which is sort of whether or not you're going to treat plaintiffs the same.
Well, if you commence interest after serious injury is found,
Yes.
it encourages early resolution of that dispositive issue and swift disposition of non-serious cases.
Well, I would think that the reason they're bifurcated on the damages and not on the summary judgment beforehand is because they need the testimony, and that you can't do on the papers. So it's a function of, in part, the bar that's been set by the legislature.
Well, when you say bifurcate liability and damages, there's actually a lot more flexibility there. I mean, a court could resolve serious injury on summary judgment. And the
Yes, they
court-
could. That was my point, that there may be some of those cases, but then there may be some where you can't do it on the papers. You got to get live testimony.
That's right. So
That's
you-
usually when you need the plaintiff to describe the injuries.
Right, so you could try serious injury together with negligence. You could try serious injury separately under CPLR 603, which is the site for which I was grasping when I was answering Judge Troutman. You could try the case in the conventional way, with all issues heard together in a single trial. Ultimately, when and how,
And the state wouldn't object to that. The state would be totally comfortable with that.
I'm sorry?
The state would be comfortable with that. With injecting into the trial issues that might be emotional and otherwise sway the trier of fact.
Well, you could always have a limiting instruction, for instance.
Counsel, can I ask you, is there any practical reason why when a plaintiff in a motor vehicle case makes a motion for summary judgment on liability, as this plaintiff did, that you couldn't cross-move for summary judgment on threshold?
We could. In this case.
You didn't, but could you?
No, we didn't. But absolutely you could.
You cross-move for summary judgment on threshold?
We did not in this case.
Right.
But one could do that. In fact, the Licari case encourages courts to use summary judgment, encourages defendants to go out and move for summary judgment on the threshold issue. Ultimately, when and how to present the issue of serious injury is a matter of trial strategy. And judges have flexibility in structuring trials, and parties have flexibility in structuring how their case is going to be put on. And the judicial process that's very familiar to the judicial process. So once the parties know that, okay, I'm going to get interest only
Can
from
the judge proceed in a bifurcated path, right, bifurcated on these issues, even if the parties object? Or perhaps if the plaintiff objects?
Yeah, the court has discretion to do that.
Yeah. So then the plaintiff would pay the price even though they were willing to try and put this evidence in? Or at least you wouldn't have to pay the price. That's actually the way that works out.
I suppose so. If they wind up winning,
Yes. Yes.
interest would start running from a later point.
Yes, yes.
That's assuming, they have the option of moving for summary judgment. They can ask the judge for a separate trial. They can make that point. If the court abuses its discretion in structuring the trial, of course, that's an issue for the appellate division.
I see.
And the appellate division can make a corrective ruling on that. I'd also like to point out that when one reads just to conclude, if I may, when one reads the opinion that came out after trial, it not only decided serious injury and damages, but it also decided causation. We had an argument that the claimant's shoulder condition was not caused by the accident, but pre-existed. Causation is an element of common law liability. So even if you accept claimant's argument about common law liability, causation was not decided until the same time as serious injury. So that likewise requires affirmance. Thank you.
Try to be brief as I can. Chief Judge, you mentioned something that is important here, and that is that 3 of the departments find that serious injury is a question of damages, namely the 1st, 2nd, and 3rd, and the 4th department, the department that this case was tried under, believes something different. In this situation, there is basic unfairness. Yeah? The 4th department has set up a different standard as to how they treat motor vehicle folks than the 1st, 2nd, and 3rd.
Depending on what you say, that may be unfairness to the state and the other 3 departments. But I'm sorry.
Your Honor,
I was going to ask you, how did Rodriguez affect this issue in the trial court?
So, as the record shows, and I was involved in this, right? So, as the record showed, we made a motion beforehand for summary judgment on liability with Judge Fitzpatrick. And she said that I won't get into the facts that we tried, but basically this woman lost control, the Parks and Rec person hit our guy. But basically said, well, because there was hay flying out from the back of his thing, maybe that was comparative negligence. Then this court ruled in Rodriguez. And Rodriguez, we brought a motion to renew the decision, or re-argue the decision. And she said, you know what? Yeah, you're right. Summary judgment should be granted, and I'm going to toss the comparative because that didn't really exist. So that was the situation.
So did Rodriguez, the holding, affect that re-argument motion substantively? I know it was the vehicle you got in, but it was based on Rodriguez's decision that now she could do what you had asked.
That's right, and she revisited the facts. So because the reason she said we couldn't get summary judgment is she said, oh, maybe there's a question of comparative.
Right. So in light of Rodriguez, which is a fairly recent decision and came down kind of in the middle of we should expect to see more of this issue arising, right?
Your Honor, I'm not so sure, because if you look at Rizicki and cases that have determined that afterwards, I mean, a lot of things have to be in play here, right? And number one, and speaking from a practical standpoint, because I'm a trial lawyer and this is what I do, you have to have this exact situation, meaning a bifurcated trial. You have to have a situation where serious injury is determined afterwards. And maybe more importantly, you have to have a client who's willing to say, I think that this is patently unfair, so I'm gonna ask the court to determine it. Because as it sits right now, there's a really an untenable dichotomy between what Rizicki says and how other personal injury actions are dealt with. If we have a 240 or 241-6 case and we get summary judgment on that case, we get interest from the date of that determination up until the date that the jury or the trier of fact comes back. If there's a slip and fall or a medical malpractice, in those rare circumstances on medical malpractice, we get interest from that. The statute never distinguished that it shouldn't be allowable, right? So it's a problem, and a bigger problem, I think, and the one that I'm asking this court to address is 3 departments are out there, and there's,
And I understand, it's just the question I'm obviously having trouble with is, we get splits here, we try to resolve splits between the departments, obviously, but it's not a split in the department that will cause us to waive our preservation rules, right?
I understand that, but you have the ability to do so, and the question is, should you do so when you have this situation where people in different parts of the state are being treated differently? If I'm driving in Manlius, New York, and I drive over 100 feet into Casanova, New York, I am treated differently, and that is patently unfair. And
And even under Tolero, that's not a factor, right?
Well, you have the ability to do so, Your Honor, and for fairness, I believe, and it's just me, right? I believe that this court should take that up.
Thank you.
Thank you very much.